today.
No. What is your question? No, 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 Mr. Elizondo, no.
Your Honor, respectfully, as a bailor and grantor, I've granted this court equitable title for settlement of any
No,
charges.
sir. This is a criminal court. No, sir. Mr. Elizondo.
Your Honor, for the record, respectfully, I am a Texas common law free man. I do not participate in corporate Ponzi schemes that require me to have
This
registration.
is not that, sir. This is not. Mr. Elizondo, stop. No, Mr. Elizondo, stop. Mr. Elizondo, stop. Mr. Elizondo.
Of trust
Mr. Elizondo, stop.
Things just got heated in the courtroom, and you're definitely going to want to see how this plays out. In today's case, we've got yet another self-declared sovereign citizen facing the judge, and the exchange between the two escalates. Quickly, what's the issue this time? Believe it or not, it all started over a minor charge, driving without valid insurance. The fine was only $100, a routine penalty in most courts. But instead of simply paying it, this defendant mailed in $3 and then showed up in court ready to deliver a full sovereign citizen lecture. Yes, really, $3, and now we're in the middle of a full-blown ideological standoff. You have to ask yourself, is this a courtroom or a clearance sale on legal consequences? The logic here is baffling. It's as if he believes a token payment somehow overrides the law, or that his self-defined status makes him untouchable. But let's be clear, that's not how the justice system works, and Judge wasn't about to entertain that kind of argument. Now here's something odd that caught my eye. Did anyone else notice the whiteboard in the background? At first glance, it almost looked like this hearing was happening in a classroom. It really makes you wonder, is this man actually a teacher? If so, it's a little unsettling to imagine someone promoting these beliefs to students. But that's just speculation. Let me know in the comments what you think. Did you spot it too? Regardless, what happens next is a total breakdown of fantasy versus reality. The judge, calm but firm, pushes back against every bizarre claim. It's a reminder that while you're entitled to your beliefs, those beliefs won't exempt you from basic legal responsibilities, especially not in a courtroom where the law is what matters. Let's jump into the footage and watch how the judge handles this situation with authority and clarity, shutting down the sovereign citizen narrative one claim at a time.
Good morning, Your Honor. My Christian name is Jose, and my family name is Elizondo. I am the bailor today, and respectfully ask some issues to raise.
Wait, Mr. Elizondo, wait. Jose Elizondo, I show that you have one case pending, and that is expired registration. Do you understand that's the charge that is pending against you?
Yes, I understand, but respectfully.
Okay, sir. Okay, hang on. There's several steps we need to take over. Were you able to hear my explanation about defendant's rights and options that I went over at the start of court?
Yes.
Do you have any questions about those rights or options?
Yes.
Go ahead. What's your question?
Okay, respectfully, I haven't received my documentation that I requested in a timely manner to proceed today.
No. What is your question? No, Mr. Elizondo, no. What is your question about the rights and options that I went over at the start of court?
I have no questions regarding that.
Okay, then to this charge of expired registration, actually, I'm going to stop and say, you mailed in payment.
I did.
You mailed in $3 and you have a balance due of $129. So with that payment of $3, we've already entered a plea of no contest for you because Texas law allows that to be entered for you. So we're set here to determine, are you able to make the balance of your payment by Monday, or do you need some time to pay that out?
Your Honor, respectfully, as a bailor and grantor, I've granted this court equitable title for settlement of any.
No, sir. This is a criminal court. No, sir. Mr. Elizondo, this is not a civil court. There are no parties like that in this proceeding. You're a defendant. You're not a grantor. I'm the judge. And so that does not apply to this court. You may have read that might be something in a civil court. That does not apply here. So my question to you, sir, is since you've already mailed in payment and indicated a plea of no contest by mailing in a payment under Texas law, can you get the balance paid by Monday, or do you need some time to pay that out, or do you have a financial situation that you need a financial packet?
Your Honor, for the record, respectfully, I am a Texas common law free man. I do not participate in corporate Ponzi schemes that require me to have registration.
This is not that, sir. This is not, Mr. Elizondo, stop. Mr. Elizondo, stop. This is not the time to make a statement. You see, we have like 12 other people who are set here. You're set on a criminal charge. This is not time for you just to go and make a statement about a civil matter that it is not said in this court.
So are you saying that I don't have civilian due process of law?
No, but you're not, this is not a civil matter. You're raising terms in regards to this as if this were like a civil lawsuit. This is a criminal charge where
It's
you've
not
already.
criminal, Your Honor.
Yes, it is, sir. This is a Class C criminal charge in Texas, displaying an expired registration. That is a Class C criminal charge, and you mailed in partial payment. So I'm trying to determine, are you able to make the rest of your payment by Monday, or do you need some time to pay it out?
I have the right to equitable title for this settlement or any charges on the doctrine of trust merge.
This is
And
not a matter. This is not a matter of a
respectfully,
title to a vehicle or anything like that, sir. You seem to be confusing some civil law
Well,
with the
I
pending
have
criminal.
some confusion because on Supreme Court case law Murdoch versus Pennsylvania, they clearly state that you don't need registration or insurance for private personal travel, and I don't consent to any corporate Ponzi scheme.
Let's take a moment and talk about what we just witnessed, because this right here is a perfect example of why virtual courtrooms, while convenient, can sometimes lead to absolute chaos. The defendant in this case has completely hijacked the hearing with long-winded, irrelevant rants, and you can tell the judge is doing her best to stay composed. But seriously, does anyone know if there's a mute button for this kind of nonsense? The entire exchange has gone off the rails, and it's painfully obvious this individual has no intention of resolving the issue. He owes $100 for a basic insurance violation, and instead of simply paying it, he sent in $3. Yes, $3. It's as if he thought tossing in a symbolic amount would somehow pause the legal process or confuse the system into backing off. Let's put that into perspective. Imagine walking into a coffee shop, tossing a few crumpled bills on the counter, and expecting a premium drink in return, despite being nowhere near the actual cost. That's not how transactions work, and it's definitely not how the justice system operates. Even if he thought it was a partial payment, it holds no legal weight in this context. Courts don't just dismiss cases because someone made a small, random payment that doesn't fulfill the order. It's hard to tell whether this was a calculated move or just another example of someone misunderstanding the process entirely, but either way, it didn't help his case. If anyone caught his reasoning behind the $3 payment, I'd really like to hear it, because from where I'm sitting, it looks like he's trying to apply board game logic to real-world law. And let's be real, court doesn't play by Monopoly rules. Let me know your thoughts in the comments. Was this some kind of tactic? Or just another misstep from someone committed to ignoring the facts? Either way, it's a lesson in what not to do when facing a courtroom.
Okay, well, this is nothing to do with a corporation. This is a Texas charge, and you've already mailed in a payment for this. So you've indicated a plea of no contest. Are you saying that you're not pleading that? Then why
Your
did you
Honor,
give them $3?
as a bailor and grantor, I gave
No,
this
no,
court
Mr.
equitable title for
Elizondo, stop.
settlement
Mr.
of
Elizondo,
any
stop.
charge under
Mr. Elizondo.
doctrine of trust merge.
Mr. Elizondo, stop. Why did you mail in $3?
Because as a bailor and grantor, I have granted to this court equitable title for settlement of any.
No, sir, we do not settle.
charges
Sir,
under trust
Mr.
merge.
Elizondo, there's no party in a criminal charge that's called a bailor, and you cannot claim a position that is not one in this court.
Your Honor,
There's
are
no
you giving
status
me-
of bailor.
Are you giving me finance?
No, sir, listen,
Oh.
I need you to listen to me. I need you to listen to me. There's no status of bailor or grantor in this criminal court. You may have read some cases in regards to some other matter. You are a
can you give
defendant.
me-
No, Mr. Elizondo, you need to be quiet and listen. You're a defendant. You mailed in $3, which is partial payment of a total of $132. All right. Now, by law, when you mail in a payment, a plea of no contest is entered. All right. So my question to you was, when you mailed in the $3, was that your intent to make a partial payment, requesting a payment plan, or were you attempting to post a bond?
My intent was, like I said, I am the bailor and grantee. I have granted this court equitable title for settlement of any charges under doctrine of trust merge. That's my answer to your question.
Okay, that is not an answer that applies in criminal court. So based upon your payment of $3, the court has already entered a plea of no contest, and I'm going to order that you get the balance paid
Your Honor,
within 30
respectfully,
days.
Okay, Your Honor, respectfully, with those documents that you have, I didn't receive any documentation requested in a timely manner to proceed today. Outlined in my quo
Sir,
warranto under
if
Chapter
you,
66 of Texas Civil Practice Code, which
okay,
is proven
stop,
both
Mr. Elizondo,
and
Mr. Elizondo, stop. The Civil Practice Code does not apply to this courtroom. This is the Code of Criminal Procedure applies to the criminal courtroom. So the Civil Code does not
but
apply.
I still have a civilian due process, Your Honor.
Well,
And I
yes,
have not
but
entered a plea.
you did by mailing it in. By mailing that in, that's entering a plea of no contest. You mailed in a payment of $3.
Your Honor.
You can
Like I
get the
said,
balance paid.
the reason why I did that as a bailor and grantor, like I stated multiple times, I've granted this court equitable title for settlement
Okay,
under
Mr.
any
Elizondo,
document plus merge.
Mr. Elizondo, were you wanting to plead not guilty and request a trial?
No. Respectfully, Your Honor. Constitutionally, too. For the record, I am a Texas common law free man. I do not participate in any Ponzi schemes that require me to have registration and insurance. I do not consent quasi jurisdiction. Respectfully, Your Honor, I plead for a civilian due process of law.
Okay, well, you're
Under Section
receiving,
1, Article 10.
okay, Mr. Elizondo, you're receiving the exact same due process that every other person who's appeared in this court has. And you have mailed in a payment of $3, and that payment is received as a plea of no contest.
Who is my accuser, Your Honor? Respectfully.
The state of Texas. That citation that you received, that is the accusation. And
Okay,
so,
well, I would like to go to trial for this.
So you're indicating that you wish to change your plea from no contest to not guilty?
Yes.
All right. And you wish to waive your right to jury trial, or do you wish to request a jury trial?
No.
So no jury trial. You wish to waive your right to a jury trial?
1 second, please. Never mind. Give me a jury trial, please.
So you wish to request a jury trial?
Yes.
And you will be representing yourself, or will you be retaining counsel?
Myself.
Okay. Do you understand that if you request a jury trial, if you're found guilty, in addition to the regular state court cost, there is an additional jury trial court cost that's assessed if you're convicted. Your case is going to be reset for a pretrial hearing that is going to be for our May contest docket, which is at 6 p.m. on May 7th.
Attacked and assaulted and kidnapped 2 different times, just one time. Recite your oath of office, your delegation of authority order, and your bond information.
What is your name?
I am Brian. My family name is Wilkinson.
All right. We'll go on the record in State of Kansas versus Brian J. Wilkinson. Case number 25 CR 67. The state appears by County Attorney Darren DeVinny. Mr. Wilkinson appears in person by Zoom. We're here for a first appearance. Mr. Wilkinson, you're appearing by a summons. I'm going to go over your charges with you. There are 3 counts, all alleged to have occurred on June 4th, 2024 in Butler County, Kansas. Count 1 alleges you were in unlawful possession of methamphetamine. That is a level 5 drug felony. Count 2 alleges you are in unlawful possession of paraphernalia for use. That is a Class B non-person misdemeanor. Count 3 is an allegation of possession of marijuana, also a Class B non-person misdemeanor. Do you understand what you've been charged with, Mr. Wilkinson?
I do not understand, Your Honor.
Okay, what don't you understand?
I had thought that this matter was already settled on the case that Mr. Watts was representing me for.
Okay, I'm not aware of that particular matter. That may have been a different case. I'm not sure.
Well, there wasn't a different case. I mean, I wasn't attacked and assaulted and kidnapped 2 different times, just one time.
Mr. DeVinny, do you know anything about another case involving Mr. Wilkinson?
Let's see. Well, I know there's criminal history. I know he's a B on the grid. He has out of at least Butler County cases, we've got a driving while suspended, an old a 23 traffic case that's closed. And then he has this open case now for possession of methamphetamine.
Do you know of, is there one where Mr. Watts representing that you know of?
Not that I'm aware of. Well, Your Honor.
All right. Well, I don't know, Mr. Wilkinson. That can be sorted out. Can you afford to hire an attorney to represent you?
I'm sui juris.
Excuse me?
I'm sui juris, and I would appreciate it, Your Honor, if you would recite your oath of office, your delegation of authority order, and your bond information.
I'm not going to do that, Mr. Wilkinson. Can you afford to hire an attorney?
I am not a ward of the court. I'm not an idiot. I know how to speak for myself.
Okay. Do you wish to represent yourself?
Well, I am myself. I can't represent myself, but yes, I will be talking for myself.
All right. You understand you have a right to have an attorney represent you on this case?
Yeah, but that makes me a ward of the court if I am seen as too stupid to talk for myself.
Have to say, the level of delusion in this moment is almost unbelievable. This man genuinely thinks that saying respectfully before interrupting a judge is going to somehow soften the blow or earn him a pass, as if politeness cancels out court protocol. Spoiler alert, that's not how courtrooms work. You don't get credit for tone when your entire argument ignores the law, and can we take a moment to talk about what's going on in the background? That whiteboard behind him is raising a lot of eyebrows. From what little I could make out, it almost looks like something out of a classroom. If this man is actually a teacher, that's more than just ironic, it's a bit concerning. Imagine standing in front of a class, teaching young minds, while believing you're exempt from traffic laws because of some self-declared status. If any of you were able to read what's written on that board, definitely let me know in the comments. Because if we've got a sovereign citizen trying to pass off these ideas to students, that's an entirely different conversation. It's one thing to misunderstand the law. It's another to misinform others. Now here's a detail that not everyone realizes. Courts actually have the authority to fine people for wasting judicial time, even if you're representing yourself. So when someone stacks baseless legal arguments, endless filibustering, and self-invented legal status on top of that, it's like asking for a second helping of chaos. You're not just making your own case harder, you're actively draining court resources. Honestly, I'd support adding additional penalties for individuals who knowingly push these discredited, sovereign citizen tactics in court. Not as a punishment for belief, but because it slows down real cases, ties up the docket, and puts stress on court staff and judges who are there to handle legitimate legal matters. But I know not everyone agrees. Some of you in the comments might say that everyone has the right to speak, even if their views are off base. Fair enough. That's why I want to hear what you think. Should courts crack down harder on this kind of behavior? Should people be fined for misusing judicial time? Drop your thoughts below. I always appreciate hearing both sides.
Do you understand that if you can't afford an attorney to represent you, one would be appointed for you?
I also understand that all attorneys' first duty is for the court and not for their clients. So
do you understand you have that right, Mr. Wilkinson?
I do understand my rights, yes,
okay.
Your Honor.
I'm going to go ahead and appoint James Watts to represent you if you think that he's represented you on something that may be in line with this case. So he'll be with you when you appear back in front of me, and that'll be on my preliminary hearing control docket. Do you have something to write with, Mr.
Yes,
Wilson?
sir.
All right. Your court date will be in front of me by Zoom on May the 19th at 2:30.
May 19th, 2:30 p.m.
That's correct. Do you have Mr. Watts' contact information?
Yes, I do, Your Honor.
You might contact his office and let them know that court date. We need to set a bond. Mr. Devaney, what's your recommendation for bond?
Your Honor, the defendant does appear here voluntarily by summons here today, so I'd request a $10,000 OR bond for the defendant.
What was the amount?
$10,000.
All right, I'll set a $10,000 OR bond. He'll need to be processed, I'm assuming.
Well, he initially had a first appearance back on June 5th of 24 at 1:30. At that point, we were waiting on KBI Labs and we released him. So I believe he's actually been arrested and processed.
Okay.
He just needs to come to 201 West Pine. If he can make it here today before 5, that's great. If not, probably on Monday to come up to the front desk so he can sign his bond.
All right, Mr. Wilkinson, can you make it up to the Judicial Center this afternoon to sign your OR bond?
It'll probably need to be Monday, Your Honor.
Before we move into the next case, I want to hear your thoughts. What did you make of that last sovereign citizen? Drop your reactions in the comments below. Personally, I think the judge handled it fairly well, though I wouldn't have been surprised if she took a firmer stance. Sometimes a stronger response might help curb these kinds of antics from dragging on longer than necessary. Still, credit where it's due, she kept her composure. Now, buckle up, because what we're about to see next takes things to a whole new level. In this next hearing, another self-declared sovereign citizen takes the spotlight, and let's just say, he doesn't keep it together. Not even close. He goes into a full meltdown and even claims, wait for it, that he was kidnapped by law enforcement. Yes, you heard that right, that it's hard to believe these situations are real, but here we are. The courtroom has increasingly become a stage for bizarre legal theories, and this case is no exception. I remember watching a similar hearing not long ago where the judge just stared at the defendant in complete silence, like he was waiting for him to finish his rant so court could get back to reality. What makes these cases so surreal is that there's no legal logic, just emotional arguments and conspiracy-style reasoning. And yet, every time, they come in with absolute confidence, as if they're about to uncover some secret legal code no one else has ever noticed. So now the question is, who's going to be worse, the last guy, or the one we're about to watch? Let's jump in and find out together, because if the opening is any indication, this one might just top the charts for courtroom chaos.